Gold.
Thank you, Your Honor. We're here in the state of Ohio versus Michael Blankenship, case number 26CR1023. The defendant is present with counsel Conchetta Rogazione and Michelle Guzzi. A one-count information was filed in this case on July 28, 2026. The one count is aggravated possession of drugs, a felony of the 5th degree in violation of Revised Code Section 292511A with a forfeiture specification. It is the state's understanding that today the defendant would like to waive his right to have the Lake County Grand Jury indict this case and will be pleading by way of information to this one count, and there is no agreement as to sentencing.
All right, Mr. Rogazione.
Thank you, Your Honor. That is all accurate.
Mr. Blankenship, how old are you?
42.
How far did you go through school?
Graduated, did some schooling in Auburn Career Center, certification for Davenport screw machines. I'm an engineer by trade.
Are you a U.S. citizen?
Yes.
And are you able to read, write, and understand the English language?
Yes.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No.
Have you ever been diagnosed with or treated for any mental illness?
No, not diagnosed. I've done mental assessments, but
Did you get a copy of the information filed in this case?
I don't believe. Yes. Yes.
Do you have any questions about it?
No, sir.
Do you understand you have the right to have your case presented to the grand jury for them to decide whether or not to indict you?
Yes, sir.
Did you discuss that right with your attorneys?
Yes, sir.
Are you going to waive that right?
Yes.
So this is that waiver one? So
Okay.
I'm gonna sign that. Sometimes it's easier if you stand up.
Okay, sorry.
Yeah. Thank you, Your Honor. I did go over this waiver of indictment with my client prior to the start of today's hearing. I do believe that he understands it. He did sign it here in open court. I have also signed it. I am presenting it to Ms. Gold.
Your Honor, I've witnessed the defendant and Mr. Rogazione sign the waiver of indictment, and I have signed it myself in open court.
All right, I'll accept the waiver of indictment. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand the question, stop me. If you want to talk to Mr. Rogazione some more, let me know, and I'll give you more time. You understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one would be provided at no cost. Do you understand that?
Yes, sir.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, sir.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any questions about any of these rights?
No, sir.
Do you still want to plead guilty to this charge?
Yes, sir.
You understand by pleading guilty, you're fully admitting your guilt to the charge.
Yes, sir.
You understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes, sir.
Aggravated possession of drugs is a felony 5. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, sir.
If you plead guilty to the forfeiture specification, you're voluntarily giving up any right to the items listed in the specification. Do you understand that?
Yes, sir.
You understand your guilty plea may result in a driver's license suspension of between 6 months and 5 years.
Yes, sir.
You understand your felony conviction will prevent you from owning or possessing a firearm.
Yes, sir.
You understand if a prison term is imposed in this case, you might have to serve a period of post-release control as part of your sentence for up to 2 years under the parole authority.
Yes, sir.
If you are placed on post-release control and you violate any conditions, then the parole authority could return you to prison for a maximum of 6 months. Do you understand that?
Yes, sir.
If that violation is a new felony, you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, sir.
If that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, sir.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes, sir.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 12 months. Do you understand that?
Yes, sir.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, I don't think promise, right? No promise.
Has
No.
anybody promised you what I would sentence you to in this case?
No.
Do you understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes, sir.
Have you had enough time to talk with Ms. Regazione before pleading guilty today?
Yes.
Has she discussed everything about your case and answered all of your questions?
Yes, sir.
Are you satisfied with the advice she has given you?
Yes, sir.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, sir.
Do you have any questions at this point?
No, sir.
Ms. Gold, if the case went to trial, what would the evidence show?
Thank you, Your Honor. The facts would show that on June 4th, 2026, the Paynesville Probation Department searched the defendant's home in Paynesville Township, Lake County, Ohio, and the defendant's possession, probation officer located suspected psilocybin, which was taken to the Lake County Crime Lab and tested for less than the bulk amount of psilocybin, a Schedule I controlled substance.
All right, Ms. Regazione, anything to add to those facts?
No, Your Honor, thank
Mr.
you.
Blankenship, did you hear what Ms. Gold said? The facts would show if this case went to trial.
Yes.
And are those facts true?
Yes, sir.
All right, what is your plea to aggravated possession of drugs, a felony 5?
Guilty.
And what is your plea to the forfeiture specification?
Guilty.
Mr. Regazione?
Right, I'm gonna sign there. Today is August 4th, 8/4/26. And Your Honor, prior to coming into court today, I did go over this written plea of guilty with Mr. Blankenship. I do believe that he understood it. He did sign it here in open court. I have also signed it, and I am presenting it to Ms. Gold.
Your Honor, I have witnessed Mr. Regazione and the defendant signed the written plea of guilty, and I have signed it myself in open court.
Mr. Blankenship, is this your signature on the written plea of guilty?
Yes, sir.
Did you sign it voluntarily?
Yes, sir.
And do you want me to accept your written plea of guilty?
Yes, sir.
All right, I'll accept the written plea of guilty. Defendant was present with counsel, advised of all of his rights, made a knowing, intelligent, voluntary waiver. he understands the nature of the charge and consequences of his guilty plea and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept the plea of guilty and find him guilty of aggravated possession of drugs, a felony 5, and the specification. I'll refer this for a pre-sentence report. Sentencing will be September 18 at 1 p.m., and I'll set the bond at your own recognizance. Anything further, Ms. Gold?
No, Your Honor, thank you.
Mr. Gazione?
Your Honor, I would ask for a drug and alcohol assessment as well. And I would also just note for the court that Mr. Blankenship is currently serving a sentence, and his out date is not until November 2nd.
All right, I'll order a drug and alcohol evaluation as well.
Thank you.
All right, we're adjourned.
All rise. I'm ready for you.
Okay, thank you.
So I think that's that.
You have the vote.
I have OR. Thank you. All right, so he's given you what's called an overcognizance bond. So that means that basically you are going to be out of custody on this case, even though you're serving the sentence on your misdemeanor case.
Okay.
So that might mean you can still be a trustee.
Okay. That would be cool.
Okay, but
Will you please have Bob witness it
I
instead
Yes.
of you? Perfect,
Yep.
thank you.
We definitely
Thank
do
you,
that.
Bob.
yes, so that's something that I'll explain to you. But this is saying that you understand when you're out on
Council,
your
before
own
you start, let me grab
recognizance.
one more thing.
Okay, when you're out on your own recognizance, if you miss court, you can face and you will get charged with a failure to appear. That will be a felony of the 4th degree. That's punishable by up to 18 months in prison, a $5,000 fine, or both, and that's in addition to the case that you already have.
I'll be in jail the whole time, so.
But if you
Right,
were to
right,
get
right,
out
right,
for some
right.
reason, you have to make sure you come to court. And we went over those bond conditions, you have to follow those. So, if you get out, you have to keep all of that in mind, and you have to know when your court dates are.
And what was it called? You said that might keep me in trustees? Is it the reconnaissance, or what part of it?
So because this is an own recognizance bond, so
Okay.
what that means is instead of posting money to get out, you're promising you'll come back knowing that you're facing additional charges if you don't.
Okay.
So what that means is
That's that.
once this gets processed, you are technically released on this case, even though you're in on a sentence. You're not getting out of jail,
Okay.
but you're not in jail on this case.
Okay. Okay.
Okay?
So I'm still serving my time
maybe
from
that
the
will
other-
let you be a trustee still.
All right. I got a
I'm
couple.
not sure.
I went to school a couple of
It might.
COs, so I'll ask and find out.
I mean,
Okay.
because technically you'll be out on that one.
Exactly.
Yeah.
So there won't be a whole-
Because
Oh.
it's not gonna be out. No,
Right.
it's not out, but
Okay.
technically, so maybe.
Well, whatever you need us to sign, we will sign,
It's
so.
just that one.
Okay, so you're gonna sign this, is it okay if he signs now?
Mhm.
Okay, so you're gonna sign that, and print your address and phone number.
Where's the other case from, Council?
Painesville Municipal Court.
It's a sentence.
It's 150 days on a probation violation. So
It's
he's
actually gonna be a
serving.
sentence, then this one will be 40 when it's out, so. probably-
Yes, yeah, because,
Okay. That's it.
all right, so can I just show Michelle this real quick?
Yep.
So this is the OR paper, and this is, sometimes we get these at arraignment too.
Yes, and
So we always have to have it witnessed
then by someone else.
by someone else, so you would never have them sign unless someone else is available to witness
Right,
it.
yeah, they.
Okay.
I'm showing from here, just, usually I'll witness it,
Okay.
Mhm.
because if somebody comes up and I just testify to it.
Right, but at the jail, you can ask a CO to witness it. Oh, yeah. Yeah. We just can't do it as the attorney because, like Bob said, if the person doesn't appear, then we're the ones that get
Right.
subpoenaed, and that's a problem.
Yeah.
So I take that? and leave
You
that?
can,
Yeah.
yeah, you could take that with you. All right, now, here's the thing. You are going to be doing a pre-sentence report like we talked about.
Right.
So you're gonna talk to probation and all that. And like I said, you wanna make sure that you remember it's like you're talking to the judge, so that you explain things.